I'm Dan Yager, Chief Policy Officer and General Counsel for HR Policy Association, which represents the Chief Human Resource Officers of over 250 major corporations on federal HR issues. Recently, I had a conversation with Andy Kramer of Jones Day about the Employee Free Choice Act. Andy is one of the preeminent labor lawyers in the United States, primarily representing unionized companies in numerous industries, including automotive, tire, newspapers, steel, and several others. In addition to his unparalleled labor law expertise, Andy offers these companies invaluable advice about how to resolve issues with their unions. So let me now share that conversation with you. EFCA is not really a long bill, it's only 2 or 3 pages. Does it really make all that significant of changes in the current law?
Well, unfortunately, the answer is yes, because part of the problem in being so short is it will leave to administrative interpretation many important questions, but it itself does change the law drastically. As I said, first of all, it eliminates the right of employees to decide through the ballot box. It gives the union the opportunity to be able to organize simply by having a majority of cards signed in an appropriate unit. It doesn't have to be the most appropriate unit, but it just has to be an appropriate unit. Number 2, it would allow after 130 days the union to be able to impose the terms of a contract by going to arbitration and having an arbitrator decide to select whatever the union was proposing and impose that for a 2-year term on that employer. And again, there's no standard set out of how that's even decided. And then third, it adds significant remedies both in terms of damages and injunctive relief with respect to employers in those situations.
Why do you think EFCA is such a high priority for organized labor?
This bill is about union organization, union increasing density, unions being able to move from the current 8% or so in the private sector that they represent back to levels where they maybe once were. If you think about it, in 1953, unions in this country represented some 35% of the non-farm workforce. Today, as I said, it's around 8%, more obviously if you add the public sector. This bill is about increasing the number.
From the employer's perspective, is this really about not wanting to pay people more wages, or is there something more that's at stake?
Most employers who have remained union-free or non-represented don't pay substandard wages. So the issue of the fact that somehow you're treating workers because of the fact that they're not being paid enough money is, first of all, I don't believe a correct statement. Number 2, I think this bill is about the fact of whether or not employees should be given an informed choice about whether they want to be in a union. But even more important to me, Dan, of anything else in this bill, it would be for the first time that the United States government would be involved in setting the terms of employment in the workplace. A very scary proposition.
So looking at the organizing side of EFCA, how would EFCA impact the ability of employees to hear both sides of the issue of whether to be represented by a union and the ability of the employer to weigh in on that issue?
Under EFCA, unions could petition the labor board if they have a majority of cards signed in an appropriate unit. It doesn't have to be under board law, the most appropriate unit, just an appropriate unit. And if that's the case, the board could then certify that union. Well, let me give you this quick scenario. Let's assume you run a 2-shift operation. You have 100 employees. You have 70 on the first shift, 30 on the second shift. Let's assume the union believes that the 70 employees on the first shift are vulnerable to unionization. They go out and get cards signed by those, and a majority of them sign, and let's say you have then 55 employees out of that 100 who have signed cards. None of them on the second shift. The second shift might not even know it's going on. So you're not only talking about the inability to inform employees, you might have employees actually become organized under that hypothetical, which could be a real hypothetical. It won't be a hypothetical, actually. Under that scenario, you could have employees organized who don't even know there's an organizing campaign and yet find themselves in a union situation.
Talk a little bit about the problems in negotiating a first contract.
First contracts are difficult to negotiate because they establish the rules of the shop. They establish, forget the economics. The economics might be easier to negotiate. It's the non-economic provisions. The movement of employees by seniority. Is it skill and ability? Does seniority count? The ability to contract out work. The ability to assign overtime. The ability to mandate employees work overtime, or is it voluntary? All of these are core issues in running a business.
How does interest arbitration work? Does it work well?
Interest arbitration is extremely rare in the private sector. I've been involved in it in both sectors, the public sector and the private sector. The reason you see it in the public sector historically is because public sector employees generally do not have the right to strike. They have the right to go to arbitration, have an arbitrator decide it. But even that is under a lot of constraints. In many states, they remove from the bargaining table a lot of issues because they're covered by personnel laws. They remove benefits in a number of states because they're governed by state appropriation or local issue appropriations. So first of all, I don't think the public sector is a good analogy. The private sector is even a worse analogy. You rarely, if ever, I've seen first contract private sector arbitration, interest arbitration. It is generally economic oriented, and it's oriented for people who have a long history of bargaining but are scared that the consequences of a strike on customers, like the steel industry went through a number of years ago, interest arbitration, because prior strikes in the steel industry demonstrated their customers would then go and take out orders out of order with different steel companies and affected the steel companies so much if they even settled, didn't have a strike, that the consequences of that said we need to do something to give our customers assurance there will not be a work stoppage. That's not here. I don't know of an arbitrator who is confident and capable of being able to decide what the provision should be as to the movement of employees for purposes of layoff, for purposes of promotion, for purposes of assigning work after an 8-hour shift ends. Those are all core issues that need to be decided by the parties.
What, in writing this contract, what standards is the arbitrator going to use to reach its decision?
You would have an arbitration panel, an arbitration board, appoint an arbitrator, whether it's an arbitrator and a company representative, a union representative, we don't know. The Federal Mediation and Conciliation Service would make these rules up. And let me give you a good example. What happens in the auto industry? As you know, many of the new auto companies who've come into the United States are non-union. The big three are unionized. What happens if the UAW would be successful, let's say, under this bill, and could organize Toyota or Honda or Nissan or Hyundai or whoever, and they go to the plant and they don't reach an agreement and it goes to arbitration? Does the arbitrator use industry standards? Is that the big three contract? Or is that the standards of what the companies have been operating under? This is all left to guess, conjecture.
So if either the employer or the union finds the decision totally offensive, is there a way under the bill that they could challenge the decision?
Well, again, if you have a short bill, you don't have a lot of words, and one of the words that's missing is appeal. Okay, so you don't have anything in the legislation as to how you would go about challenging it. I do believe, however, constitutionally and even statutorily, there would possibly be vehicles for an employer to challenge.
Let's talk about the bargaining process. One thing we haven't talked about is if you've got this 120-day period, are the parties really bargaining in that period?
Well, to me, one of the concerns is the whole time period. As somebody who's negotiated many contracts in a number of industries, this is an unrealistic time frame. First of all, let's just take the idea of a first contract. The union's going to want to have information. They're going to get information about the employer's practices, policies, and so on. That takes time. The union's going to pick a bargaining committee. That takes time. The union's going to formulate its proposals. That takes time. The employer's going to formulate its proposals. That takes time. We're already now in the months, not in the days. The idea that you would have a contract within 90 days or 120 days from the 10 days you commence bargaining would be, to me, just unrealistic, of people who have no idea what it takes to bargain.
Supporters claim that EFCA has worked very well, or laws like it have worked very well in Canada and in the public sector. How do you respond to that?
I would invite them to go back and look at what Canada has done. Most provinces 20 years ago went to card check recognition. I think all but one or two now have eliminated that and have gone to secret ballots. So if you look at the Canadian experience is going in the opposite direction.
So you're concerned about increased government involvement. You work with a lot of these agencies. Who would administer EFCA if it was
Well, there would be two
enacted?
principal agencies as we understand the legislation, and as I said, there's not a lot there, but as we understand it. One would be the Labor Board, the National Labor Relations Board. They will administer at least the certification and representation. They're required, in fact, under it to deal with the authorization card, what's an appropriate authorization card, what are the procedures, and they will deal with that. They'll also decide whether or not an employer's challenge, at least initially, because it can go up to a court of appeals, is appropriate or not appropriate. But we'll have an agency that no one's ever paid attention, well, not no one, but most people really have not paid attention to and really don't know much about, become really instrumental, and that's the Federal Mediation and Conciliation Service.
The landscape has obviously changed over the next few years, with or without EFCA. How do you see labor relations going? What kind of strategies do you see unions implementing, tactics being used?
Well, I do think there would be enormous change if you have EFCA, okay? Because I think EFCA would be a monumental opportunity for both AFL-CIO and Change to Win unions to renew what has already been important to them, the ability to organize new members. Some have been far more successful than others, but the point is all of them will be well motivated by EFCA to go out and to organize. We're going to see, and I think a total administrative response to that, just like we've seen historically with Democratic administrations versus Republican administrations. But we're also going to see a continuation of what's been happening over the past several years of what I call top-down organizing. This is corporate campaigns against companies designed to embarrass them, intimidate them, to be able to put pressure on them, to go a certain way with respect to issues like card check, being neutral in a union organizing campaign. All of those will become critical. Number two, the continued pressure they have on local and state governments to enact legislation, labor peace legislation, legislation designed to help facilitate the organizational efforts of unions. We're going to see more of that. So to me, Dan, we're going to see a continuation of aggressive union.
In closing, the truth about EFCA in its current form is that it's far more than a simple card check bill, and its consequences would be catastrophic for employers, American workers and their families, and our economy. Please visit our website for more information and to learn how you can get involved.